benefit of all participants, attendee lines must be muted. Should you have any questions that you would like to submit during the event, you may submit them through the chat box at the bottom of your screen. If you cannot address your question during today's webinar, we will follow up from after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have any follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Note, Dentons can only issue CLE credit for attendee during the live broadcast of the webinar. Participation on the live webinar must be on a computer or laptop device. Credit is not available for joining via mobile device. The following is a very important message regarding CLE credit. The webinar window must remain open for the entirety of the program, and it must be the only window on the forefront of your screen. WebEx will detect if you minimize the program or use computer outside of the webinar software, and this will prevent you from earning CLE credit. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you do not have a license in these states, you can disregard this. I will now be turning it over to Aaron Marcus to start the program.
Good afternoon, friends and colleagues on the East Coast, and good morning, all others. And it is a pleasure to be here with you today to talk about the Equal Employment Opportunity Commission's 5-year enforcement plan. We're here to provide an overview of what we'll describe as the SEP, which is a relatively new creation. This is the third of 3 plans, the first one being implemented in 2013. So just a decade, the EEOC has been going through this process that we'll describe today. When you compare that to the implementation of Title VII in 1964, and then the creation and operation of the EEOC the year after, you can see that what we're discussing today is relatively new. However, I find it important and instructive. One thing that's new about this particular plan that we'll discuss today is the process by which the EEOC came to develop it. Specifically, the EEOC held a listening tour. It invited approximately 35 different panelists to come in, answer questions, address their thoughts on what the EEOC should focus its resources and attention on, and its enforcement priorities. Now, my colleague and I have got a little color on the makeup of those panels and discussion, which we've found instructive and important to consider in thinking about what we're going to discuss today. But ultimately, what we'll discuss is the fact that the Commission appears poised to focus its efforts in several strategic priority areas. And these include, in the Commission's view, racial and economic justice in the workplace, workers who are particularly vulnerable to discrimination in the workplace, and this includes, among others, transgender workers, immigrant or migrant workers, individuals with intellectual or other development disabilities. We will give context to the priorities in the view of the listening sessions and other material that the EEOC has provided through the process. We'll also highlight some of the litigation that we believe features or emphasizes the EEOC's focus on its strategic enforcement priorities. First, before we get to the substance of the SEP, we'll give a bit of a primer of the EEOC, the purpose, its makeup, its authority, because all of this we find gives context to how to deal with the organization, your organizations and your clients, and how to view its SEP. But first, let me start by introducing myself. My name is Aaron Marcus. I'm very happy to be here. I have the privilege of being a litigation partner in our Louisville office location. A broad array of litigation, but primarily focus on labor and employment, as you see here from my pleased to work with you all and see you today.
And good afternoon and good morning, depending on where you are. My name is Chelsea Granville Reed. I am a senior managing associate here based out of the Louisville office with Aaron. I focus on employment and labor and other business litigation. I'm really excited to be here to speak with you all about the EEOC strategic enforcement plan and what to expect from that enforcement plan.
So before we get into the substance of the SEP, we'd like to discuss the EEOC. We'll talk about its background and mission and the tools that it has in the toolbox to carry out its efforts. So we're mindful that most of you all are familiar with the EEOC. So we'll try to run through this first part of the program with some speed so that we can get to the substance of what's in the enforcement priorities. So without further ado, we all understand the EEOC is a federal agency created by Title VII of the Civil Rights Act of 1964. It became operational as an organization in July of 1965. The mission is fairly simple. Enforce the laws prohibiting employment discrimination in the workplace. These laws focus, as we know, on different protected categories that we discussed: race, color, religion, sex, and what's encompassed therein, including, for instance, pregnancy and related conditions, gender identity, sexual orientation, the national origin, age, 40 and over, disability, and genetic information. We've got folks in our presentation today who are listening from a multitude of organizations all over the country, all over the US. And in those different states, most likely in each of your respective states, you've got, in addition to the EEOC, state agencies that also focus on the enforcement of parallel state laws governing employment. So for example, Chelsea and I are in Kentucky right now. We have in Kentucky, the Kentucky Commission on Human Rights. Most often when our clients receive a charge of discrimination, we find that it's jointly filed with the EEOC and the KCHR. And one of those agencies takes the lead on handling an investigation and review of the charge and decision making. What is the composition of the EEOC? We've seen some discussion here about the Office of General Counsel, and I would encourage you to have a look at the slide and the makeup of the office. I also just like to point out the general management structure because it's really important and instructive when we start to talk about the listening session and some of the back and forth with our different commissioners. So the EEOC, is made up of 5 different appointed individuals. Those are being appointed by the president. This includes a chair, a vice chair, and 3 commissioners. The chair is there to implement and administer policies related to financial management of the commission and its organizational development. The vice chair and the commissioners are there to develop and approve EEOC policy. They're there to issue charges of discrimination. And by a majority vote, they have the authority to authorize litigation and systemic investigation. You'll see here that the EEOC has 15 different district offices depicted on the screen. It's headquartered, of course, in Washington, D.C. These district offices, as you'll see from the screen, are concentrated in larger markets. For instance, Chicago or Los Angeles, Atlanta. There are 53 different field office locations that include trial attorneys who work out of those offices. As you saw from the prior slide, these are the individual staff to do the work of the EEOC. They're there to handle mediation. They're there to pursue investigations and litigation when necessary.
Aaron discussed, and you all are all likely familiar with the federal laws prohibiting workplace discrimination that are enforced by the EEOC. But the EEOC does periodically issue additional guidance that employers can and should utilize in analyzing workplace issues and in assessing potential discrimination claims. So among that guidance are regulations. These are utilized by the EEOC to implement those workplace discrimination laws. They can be found in the Code of Federal Regulations. They are voted on by the Commission after the public has a formal opportunity to provide comment. And one series of publications that have proved useful are the regulations that discuss guidelines on discrimination because of sex, because of religion, because of national origin, among others. For example, these guidelines tell us how the EEOC actually defines what is considered to be a religious practice. With respect to discrimination on the basis of sex, it informs the reader as to how to apply the, quote, bona fide occupational qualification exception. There are hundreds of these regulations. They are publicly available on the EEOC website, and I would encourage you to take a look at that when you're taking a look at your workplace policies. Sub-regulatory guidance explains how laws and regulations apply to workplace situations. This is an underutilized source, and in our opinion, it also consists of hundreds of documents available online that should not be overlooked by employers. For example, after the Bostock decision, where the Supreme Court held that the prohibition on sex discrimination included discrimination based on sexual orientation and transgender status, the EEOC issued sub-regulatory guidance on this exact issue. And that guidance poses and responds to hypothetical questions related to same and sex segregated bathrooms, the use of pronouns, and other related issues. Now, the sub-regulatory guidance does not have the force and effect of law, but they can be relied on as a representation of official EEOC policies. Commission decisions deal with a specific charge of discrimination. The EEOC will vote to create agency policy to be applied in similar cases in the future. One such publication that you'll find on the EEOC's website deals with a specific charge stemming from an allegation from a group of female employees that challenged an employer's failure to offer insurance coverage for contraception. And the EEOC, in issuing this guidance, included a summary of their investigation, a discussion, an analysis, and expressed the specific reasons why this action was considered to be unlawful under the applicable discrimination laws. Opinion letters are just that. They're opinions from the Commission voted on by the Commission. These letters represent the official position of the EEOC and again can be relied on as such. Memoranda of understanding explain how two or more federal agencies cooperate when their enforcement responsibilities overlap. These documents must be approved by a majority of the commissioners. And finally, informal discussion letters are response letters written by staff of the Office of Legal Counsel, not to be confused with the Office of General Counsel, to questions posed by the public. They are not considered to be official opinions of the Commission, but again, this is an underutilized resource. It's an additional source of information that employers can use to unofficially seek opinions from the Office of Legal Counsel about a specific topic on an informal basis.
Yeah, I think it's really hard to overemphasize how valuable this EEOC guidance can be, particularly the sub-regulatory guidance, which is very easily accessible on the EEOC's website. We deal in the management side for employment issues with very complex matters, disputes. And there are some times where you may find that there is guidance issued by the EEOC relating specifically to your scenario. I have found it in the past and I've thought it been useful. And frankly, what can be more compelling than citing to the EEOC or a federal court judge to guidance from the organization who is tasked with enforcing employment discrimination laws? So we'll talk briefly about the EEOC's policies and enforcement mechanism. the discussion being, what are the tools that the EEOC has at its disposal to carry out the mission? And I think you can fold it into three categories. It has the mediation policy, litigation policy, and systemic enforcement. If you're accustomed to receiving or responding to EEOC charges, you'll know that among the first decisions that your organization or your client's organization has to make is whether it wishes to participate in mediation. So shortly after the charge is filed, the EEOC may contact the employee and include contact with the employer in its system, asking whether the parties are interested in mediation. That decision is completely voluntary. If either side turns it down, the charge will be forwarded to an investigator to go through the normal process. If the parties agree, then the EEOC will take the task of setting up the mediation and assigning a mediator. If your experience is anything like mine, this is not an option often taken. Don't want to be dismissive of the importance of potential dispute resolution and mediation, but I've found that clients would prefer to respond to a charge. The litigation policy recognizes the EEOC's ability to pursue litigation by stepping into the shoes of the claimant. It's a little different, in a lot of cases, you elect not to mediate, the EEOC reviews, issues a notice of dismissal and a right to sue letter, and the case will then go to a federal court for litigation. However, in some cases, the EEOC can come in and stand in the shoes and pursue litigation itself. This has to be approved by a majority vote of the chair and commissioners, and when approved, the EEOC will then pursue that lawsuit. Some of the factors that the commission considers in deciding whether to pursue litigation include the seriousness of the charge, the type of legal issues in the case, the wider impact the lawsuit could have on the commission's efforts to combat discrimination. However, because of the limited resources of the commission, this is not, lawsuits are not frequent by the EEOC, broadly speaking. And then finally, the systemic enforcement policy, I think, can be fairly characterized as an extension of the litigation effort. It recognizes that there are times when the EEOC has to take action specifically for an issue that is likely to impact an industry more broadly. The commission defines systemic cases as pattern or practice cases, policies, or class cases where the discrimination alleged has a broad impact on a specific industry or profession or company or geographic location. Pursuing this can be done through individual charges by the EEOC or what's known as a commissioner charge. One example of a commissioner charge is in the wake of the Dobbs decision, employers implemented policies offering travel to workers for abortions where they may not have been available in one state but all in another. There was a commissioner charge charging employers with discriminating against pregnant and disabled workers who claimed by the commission that they could not receive similar benefits. So that's an example of a systemic enforcement commissioner charge. Finally, we recognize that the EEOC is a public agency. The records are subject to the Freedom of Information Act, or as we call it, FOIA requests. On the slide, you see some discussion about the confidentiality of some records and when they will not be released by the EEOC. But I find it helpful, and I like to point out one strategic reason to be mindful of the open nature of the EEOC's records. So in responding to a charge, when there will inevitably be litigation in the future, the plaintiff will have at his disposal the opportunity to receive from the commission the position statement that your organization submitted to the commission. So if there are any inconsistencies in your position statement submitted in response to a charge versus what's a position later taken in litigation, that could be used against your organization as an argument or element of pretext for discrimination or retaliation. So I always just, we're mindful to advise of the open nature of the EEOC, and it factors in when and how to respond to charges of discrimination.
All right, the EEOC strategic plan and the strategic enforcement plan. These are two distinct documents. The EEOC's strategic plan is a document that's published every 4 fiscal years. It deals with the EEOC's internal enforcement priorities and their own organizational processes. This document is aimed at establishing a framework for achieving the EEOC's mission, and it is publicly available. The strategic enforcement plan, not to be confused with the strategic plan, it is the subject of our discussion today. This document refines the information outlined in the strategic plan by establishing the EEOC's substantive subject matter enforcement priorities. For our purposes, the SEP, for short, provides us with real insight into exactly what the EEOC is seeking to target when reviewing charges of discrimination, when they're deciding whether to engage in a directed investigation, and when they're making decisions to file or to not file a lawsuit against an employer. Employers will want to pay particular attention to these enforcement priorities when developing internal workplace policies and dealing with compliance issues, and to ensure that their organizations do not become a target. All right, it is time for our CLE code word. As mentioned at the beginning of the webinar, we'll need to take a brief moment to satisfy CLE requirements by delivering the following code word on the screen. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type this code word, strategic, into the Q&A section on the right-hand side of your WebEx screen. Please make sure to hit the send button so that it registers. And in case you missed it, the code word is strategic. All right, let's talk a little bit about the EEOC's previous enforcement priorities. So we saw in 2013 to 2016, the EEOC establish these six general categories of enforcement priorities. And then in 2017 to 2021, we see substantial overlap between the enforcement priorities that were articulated in 2013, 2016, again, during that fiscal year 2017 to 2021. We're focusing on recruitment and hiring, protecting vulnerable workers, addressing emerging and developing issues. That's sort of a catch-all category. Addressing equal pay issues, preserving access to the legal system, and a common theme that we've seen throughout the EEOC's strategic enforcement plans and even into today is preventing systemic harassment. In that 2017 to 2021 strategic enforcement plan, the EEOC did expand the category of protecting vulnerable workers, expanded vulnerable workers to include underserved communities and protecting those individuals from discrimination. Now, in drafting the fiscal year 2023 to 2027 SEP, the EEOC sought input from the public through a series of 3 listening sessions. These are listening sessions that were publicized and can still be found on the EEOC's YouTube page. And they also sought input from the public through the use of a dedicated email box. During these sessions, the EEOC heard from 35 witnesses, including representatives from civil rights organizations, unions, employer and human resource representatives, scholars, attorneys representing plaintiffs and defendants in employment discrimination matters.
Absolutely. And I think that Chelsea and I would agree that the overwhelming makeup of the 35 different witnesses were majority plaintiff side or plaintiff advocate side individuals, as opposed to management side. There was notably only one plaintiff or claimant who had filed a claim with the EEOC that the commission chose to highlight in one listening session. In fact, that was the first one that I'm going to discuss here. The first listening session was held in Buffalo, New York on August 22nd, 2022. The focus of this listening session was, as you see on the slide, advancing racial and economic justice in the workplace. The selection of Buffalo, New York was not accidental. As many will recall, just months before this, there was a heinous hate crime in which there was a mass shooting of 10 Black Buffalo residents in a grocery store, in a case that's still and currently being prosecuted as a hate crime. The EEOC chose to hold its first session there to reinforce, in its words, the commitment to combating racism. And if you were to listen to that session, which, as with the others, is about 5 hours long, so it'll take some time, you will see the EEOC and the commission connecting that type of issue and other broad, nationally focused issues where there is some element of what it describes as long-standing racial injustice to workplace laws and the enforcement of those laws. So this particular program included 3 panels of witnesses, which among them was various representatives of the EEOC Buffalo local office, in fact, the director of the local office, as well as the Buffalo Urban League. There were several professors or members of universities in and around Buffalo. The commission heard from 2 family members of the victims of the Buffalo mass shooting. And as I noted before, the commission heard from an individual plaintiff, Kimberly Hayward, who was a lead plaintiff in a federal lawsuit alleging systemic race discrimination and harassment. We're going to talk about that case in some more detail today. So the commissioners asked a number of questions that, in our view, provide insight on the focus of the priorities. And these are going to show up in the SEP that we'll discuss in a minute. So, for example, some of the comments included a question from the vice chair regarding emphasizing longstanding commitments to vulnerable workers population. And they included discussion on individuals who may have a criminal record or some other involvement in the justice system where there may be, in the commission's view, employment practices that are discriminatory in effect. Commissioner Dillon, focused on the need to engage in more outreach to individual workers so that they know their rights. This is going to be really important as we talk about the priorities, because I can see just from the practice of management side employment litigation defense what the implications of a broader strategy like that might be for employers. Commissioner Sonderling discussed how to address gaps in resumes in the hiring process that may be rooted in, for instance, parenting obligations that tend to be heavily more focused on women and what impact that may have. And finally, Commissioner Lucas discussed different programs and barriers to individuals in protected statuses in the hiring process. For instance, discussions of language requirements or degree requirements in more.
Listening session 2 dealt specifically with identifying vulnerable workers and reaching underserved communities. This session was presided over by Charlotte Burrows, chair of the EEOC, and was attended by the vice chair and all 3 of the commissioners. They were all actively involved, present, and asking questions. The primary purpose, as you can imagine, was getting an idea about what the EEOC should be paying particular attention to. What should their enforcement priorities be when we're talking about vulnerable workers? What does that really mean, and what does it mean to those who are on the ground working with those groups? We heard from Marissa Diaz of Legal Aid at Work. She suggested that the EEOC pay particular attention to particular indicators of susceptibility for discrimination, specifically for immigrant workers and for migrant workers. These are individuals who might be unaware of their rights due to having a less formalized education. They're considered to be, in her opinion, susceptible because they are typically paid lower wages. which in turn increases the threat of retaliation. These are individuals who, if they were fired in retaliation for perhaps reporting something to the EEOC, they're less, they potentially are undocumented and do not and will not have access to unemployment benefits. During the session, Commissioner Dillon also posed questions relating to the role that literacy plays with respect to certain populations and asked how the EEOC can effectively reach those individuals. She talked with another panelist from another advocacy group from the California Rural Legal Assistance, who answered that the EEOC should challenge assumptions about literacy and offered a suggestion that workers should be given an alternative option to potentially call back and follow up with written materials that were submitted, or for those individuals who use sign language to communicate, an option to potentially sign using video or some sort of a video conference. Another individual, Julie Keegley from the Georgia Advocacy Office, was asked some questions from Commissioner Lucas about employer best practices. This was an interesting one. Her suggestion related to working with folks who have intellectual disabilities. She suggested and had experience working and creating what she called a discovery profile, keeping track of that individual's strengths, perhaps what time of day they work best, how often they need breaks, taking these results of the discovery profile and engaging in a process called customized engagement, working with the employer to fill in that employee's needs, which she found to be successful. All of these suggestions played a part, and you'll be able to see in the draft strategic enforcement plan that the EEOC really took those comments and suggestions seriously, and they do show up in some way, shape, or form in the draft plan.
And then finally, there was the third listening session, which was hosted on September 22nd, 2022, which I would describe as more of a summary session. It was led by Chair Burrows and included the vice chair as well as the three commissioners. There was an interesting point of contention in the listening session that was raised by one of the commissioners, noting that the viewpoint of the prior two sessions in the commissioner's view did not include a diverse set of views. And if I could read between the lines, I think the allusion was to what we discussed a bit earlier, in that there were largely in the first sessions plaintiff sides or plaintiff advocacy side individual witnesses, and very little hearing from the other side. So you might consider that lack of management side representatives from those sessions as being why there was a bit of back and forth. And in fact, as a result, the commissioner requested that the SEP be published in the Federal Register before being finalized. And as we'll talk about in a second, it was. The goal, I think in the commission's view in that listening session, was to solicit even more feedback from, frankly, all others and all sides of views on how to address work discrimination laws. So this program, in addition to the management makeup, included panelists who were involved in development and implementation of the initial SEP in 2013. If you're interested in listening to it, you'll find some of the subjects of the session included the claims of misclassification of employees as independent contractors. So if that's a part of your organization, you might find some interesting commentary in this session about that, which I can't remember the name of the witness, but was described as having been a quote strikingly focused practice on workers of color. They also discussed, as well as in the other sessions, what was described as systemic discrimination issues, again, including, for instance, language incentives or educational incentives that are tethered to actual job requirements and tend to have a disparate impact. And then finally, there was a lot of discussion on protecting workers from retaliation. There was a major emphasis on this, and I believe that there's a key distinction to understand that may not always be fully understood. And employers can have a misguided belief that because a person's claim of discrimination is false or easily disproven, untrue, that it absolves them of all liability. That's not the case, because a retaliation claim that's brought in connection with a discrimination claim is a claim that's not impacted by the merits of the underlying protected activity, whether it's meritorious or not. In other words, the claimant doesn't need to prove their charge for an employer to still be held responsible for retaliation. And if not carefully understood, they can lead to a lot of issues in litigation involving discrimination cases. There was very much discussion on that in the third listening session. And so again, if interested, I would encourage you to review and listen. So, as we discussed, at the request of one of the commissioners who took issue with the makeup of panelists, the commission published the SEP in the Federal Register. It's available at the website listed in the material provided, and it's about 10 pages long. And Chelsea and I would like to go through and highlight some of the notable enforcement priorities. We'll also give some commentary from our review of the listening sessions, just to give a little color as to what the commission intends to focus.
Yeah, that's right. The 2023 to 2027 draft SEP was the first one to be formally published in the Federal Register. It was published on January 10th of this year, and the comment period did close on February 9th. You will see, as is on your screen right now, that we've got common themes that we've seen since 2013 through 2021. But the EEOC has expanded and refined those subject matter priorities extensively in that publication, incorporating many of the discussions from the listening sessions and signaling to employers that targeting systemic discrimination remains top of mind. Taking a look at the recruitment and hiring subject matter priority, the EEOC has refined that and is working on eliminating barriers. So they've signaled that they will target employers where it appears that they are steering and segregating individuals into a specific job or a specific job duty based on membership in a protected group. We have seen this allegation being brought up with individuals with physical and intellectual disabilities, pregnancy-related discrimination claims as well. The EEOC has signaled that they'll be taking a closer look at restrictive application processes or systems that make it difficult for individuals with, for example, disabilities or other protected groups to access, or which restrict on a systematic level certain individuals from being hired or recruited for positions, for example, on the basis of an arrest record or a conviction record that isn't actually tied to business necessities.
Yeah, absolutely. And similar to that, there's an emphasis within the recruitment and hiring session on screening tools or job requirements. That disproportionately in the commission's view impact workers based on a protected status. So, for example, degrees or language preferences. There was discussion in the first listening session about language preferences for Spanish-speaking individuals. Well, in itself, that is not problematic. Presumably, there is some nature of a portion of the job that requires or is helpful to the organization to have individuals who speak Spanish. However, what the discussion in the listening session was that has found its way into the SEP was that there are cases where there may have been language preferences placed, but no actual evidence that it is tied to any factor of the job. And the commission views that as seeking to exclude individuals. So if you were seeking a preference of Spanish-speaking individuals, the commissioner's view and commentary in the listening session was, well, this was to the exclusion of Black workers or other non-Hispanic workers and would be something that they would emphasize in their priorities. There was a similar hypothetical about a college degree. I think that's a little more of a difficult argument for the commission to make in terms of job requirements, but they recognize or they discuss the notion that companies would use degree requirements to exclude individuals on a systemic basis. And so I thought that was also notable within the recruitment and hiring section of the SEP because of what we heard and how it directly came from those listening sessions.
We're still seeing a focus on the protection of vulnerable and underserved workers, but that category has been expanded due in large part from what we can tell based on some of what we heard and what we saw during listening session number 2. That category of workers is expanded to include those with intellectual disabilities, those with arrest or conviction records, LGBTQI+ individuals, and those with limited literacy and English proficiency.
You know, if you could categorize the listening sessions and this SEP into 2 different categories, you know, one of the emphasis would be, you know, how the commission will pursue enforcement actions, but the other one was highly focused on how the commission can be more informative in the community, more informative to workers, explaining their rights, what the commission does, why it exists, and how an individual may go about pursuing a charge or claim of discrimination. Included in this vulnerable workers section in the SEP is discussion about how the commission may go about doing that. And that's laudable in itself. I think it's great, and individuals should absolutely understand their rights in the process, because I think employers are by and large doing the right thing and making an effort to run a business, but also treat people equitably. But what I can see as an outcome of that is more charges, and particularly more charges by individuals who are still employees. And if you've dealt with those, I think you will find that they are exceptionally difficult because they create a fertile ground for claims of retaliation. And it just further emphasizes the need to understand how to deal with individuals who have engaged in a protected activity like filing a charge of discrimination and avoid claims of retaliatory behavior.
We're also still seeing a focus on equal pay issues. In articulating this priority, the EEOC provided some more specific examples. They specifically stated that employees are less likely to report pay issues because they're typically unaware of how their pay compares to their counterparts. And in this respect, the EEOC made clear that it will concentrate specifically on combating employer practices which appear to impede equal pay or that may lead to violations of statutes related to pay that are enforced by the EEOC. This might include retaliation against employees for asking about pay, the implementation of what are called pay secrecy policies, reliance on past salary history in establishing one's pay, and requiring applicants to specify their desired salary before, during the recruitment and hiring process.
You know, we discussed earlier the different tools in the toolbox for the EEOC, and one of them was being able to pursue its own charges, not just in the shoes of a claimant. And I think that the equal pay portion of the priority plan, and if you read the SEP, you'll find that the EEOC probably would consider this one that lending itself towards commission-related action. So, for instance, workers generally don't know the pay of their coworkers. They don't know what they don't know about whether or not they're underpaid on some discriminatory or disparately impacted basis. But the EEOC has the ability to get that data, or it may already have that data, and elect to pursue systemic investigations or other charges based on that. So this may be one area where we see the commission focus more on its own enforcement powers.
We're also seeing a continued focus on access to the legal system and preservation of that access. So on this point, the EEOC has discussed preventing the implementation of policies and practices which limit substantive rights for employees, that discourage or prohibit individuals from exercising the rights that they have under those employment discrimination statutes that are enforced by the EEOC, or which impede the EEOC's investigative or enforcement efforts. You'll see this in challenges to overly broad waivers, releases, and non-disparagement provisions. Another area that you'll see this in is that in challenging an employer's failure to keep employee data as required by statute and regulation. And this is one that can become pretty apparent at the early stages. If an employee files a charge of discrimination, employers required to respond to that particular charge, the EEOC could take a look at that charge response, make a determination that they'd like to engage in further investigation, particularly that are directed in requests for production of documents. And it would become apparent at that stage that the employer might not possess certain documents or is not keeping adequate records as required by law.
Absolutely. And in the SEP, you'll find that the commission chose again to emphasize the issue of retaliatory practices. And it considers, as a part of this access to the legal system priority, any practices that may discourage employees from filing other charges or engaging in further protective activity because they've already done it in the first place. So that's expressly in the SEP under this portion of the plan, as well as others. So again, I reiterate, it's an important factor of the discussion of creating a plan, and it's a part of their enforcement priority.
Systemic harassment, I see this as a common theme throughout all of the enforcement priorities. It remains a topic for the EEOC. In fact, they specifically stated that in 34% of the charges of employment discrimination that the EEOC received between 2017 and 2021, 34% of those included some allegation of harassment. And it is on this basis that the EEOC made clear that a claim by an individual or a small group of individuals may very well still fall within the purview as ripe for charges or litigation if it's related to a pattern or practice of harassment.
Chelsea's absolutely right. I totally agree with that. And you can also reason in understanding that more than a third of claims or charges filed with the EEOC include a claim of harassment, that the commission will devote quite a bit of resources on pursuing harassment-related charges or systemic investigations or systemic litigation plans focused on stemming harassment.
And then this last category is sort of a catch-all to address emerging and developing issues. There's a wide variety of issues that fall into this category, some of which include qualification standards and inflexible policies that discriminate against individuals with disabilities, protecting individuals impacted by childbirth, related medical conditions, and pregnancy under the Pregnancy Discrimination Act, as well as pregnancy-related disabilities under the Americans with Disabilities Act, addressing discrimination which stems from local, national, and global events. And then, of course, a topic that we've been dealing with for several years now and will continue to see is discrimination arising from COVID-19, such as medical inquiries and denials of accommodations based on sincerely held religious beliefs.
Yeah, and I would just reemphasize the language in this section that I find a little vague and unexplained. And that is what Chelsea mentioned as addressing discrimination influenced by or arising as a backlash in response to local, national, or global events. Well, what does that mean? Well, the one obvious example is COVID-19, where you will have seen backlash or uh, 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 actions motivated by hate and targeting to Asian communities, or issues involving vaccination and sincerely held religious beliefs. But COVID-19 aside, what other types of local, national, or global events might influence the EEOC's priorities? Then notably, the SEP includes caveat that these priorities can change this particular portion. And so it sort of leaves a little more question. And I certainly found that to be um, curious and worthy of further inquiry.
There is one thing that sort of stood out in this particular SEP, and that was the discussion of artificial intelligence and the use of automated systems. The EEOC has made specific mention that it does intend to target employer use of automated systems, including artificial intelligence, machine learning, to target job advertisements, to recruit applicants, to assist in hiring decisions, which intentionally exclude or adversely impact protected groups. We've actually been able to see this play out, although in more preliminary stages, in recent litigation that was brought by the EEOC against an online tutoring company in a federal court in New York, which we'll talk about a little bit later. This priority is in keeping with the way that the EEOC seems to be trending on this issue. In 2021, they announced an agency-wide initiative called the Artificial Intelligence and Algorithmic Fairness Initiative, aimed at ensuring that the use of software, AI, machine learning, et cetera, used in employment decisions does comply with civil rights laws.
So now we've talked about the SEP, the process of getting there, what some of the strategic priorities are. I wanted to share with you a case and talk about some of the discussion and the claims made in this case, because I think it's notable. You'll recall from the first listening session that there was one individual who was a plaintiff. The commission invited and chose to hear from this individual, Kimberly Hayward, to discuss her claims against her employer. These are claims that are pending in court. We'll talk a little bit more about them. But what's important is that the commission found it worthy to hear from, and this was a process used to influence his priorities. So we decided, well, let's take a look at this case. Let's see what the record says, what the claims are. We've reviewed the case file, the materials, and pre-litigation, and I wanted to just pull out and highlight some of the factors involved in this case so that you can be mindful of them in your workplaces and also maybe better understand a little bit about the SEP and its strategic priorities. So, who is Kimberly Hayward? Well, she's a former environmental services worker at a hospital system in Buffalo, New York. And I'm going to talk about a little background of the case and procedural history as to where we are and how we got there. There are actually 6 plaintiffs and claimants at the EEOC level involved in this, Ms. Hayward being described as the lead. So these claims originated in New York State Division of Human Rights. You'll recall this being the state agency focused on enforcing the state parallel employment laws. And the plaintiffs filed their charges, 6 of them, with similar claims of harassment and discrimination. Much of it is included on the screen here, so I won't repeat it. We've got a short amount of time, so I'm going to push through. Well, what's interesting, you'll note that, okay, if the EEOC found it important to hear from this individual and we realized that she has pursued claims in court as well as the other plaintiffs, why did the commission decide to bring its own charges if this were right with the indicia of its strategic important priorities? Well, the answer to that is because the claimants chose instead of the options that the EEOC would have had to pursue, that they requested that they get notice of dismissal and right to sue letters to pursue their own claims in court. And the DHR and the commission complied. They issued right to sue letters, and the plaintiff thereafter filed the case. Actually, I believe in state court, and then removed it. It was removed to federal district court. So you see some of the claims that were made. I'll just point out a few others. There were claims by Ms. Hayward and others that sort of overlap, that management was rude and disrespectful. There are claims that white employees on certain shift were rarely or required to work in COVID rooms, whereas Ms. Hayward, who is Black, and the other claimants, several of whom are Black, did not have those similar assignments. And in fact, she and others were required to handle tougher assignments as alleged in the complaint. There were claims by some management level Black employees that they were treated differently and in their view mistreated by senior directors or managers who would not engage them directly. There are a number of other claims, and I think it's important to note they all sort of overlap and factor into one another. But I want to point out just a few notable aspects of these because they relate to the SEP. Things that we can glean from the case. You'll see some on the screen, and I encourage you to review those in the material. But there are some others I want to point out. There were multiple claims. So you're talking about similar allegations by multiple individuals. This aligns with the commission's view of uprooting what it describes as systemic discrimination in the workplace. There were claims, if you read the file, of a joint employer relationship. This is also a part of the priority and includes claims about the failure to hire individuals from temp workers to permanent. And this aligns with that recruiting and hiring enforcement priority. And then finally, discriminatory scheduling and job assignments also goes back to that recruiting and hiring priority and focuses on the systemic aspect of what the commission seeks to go after. I would love to speak more about Hayward in this litigation and welcome questions to it, but we have a few other cases to highlight before we leave.
Thanks, Aaron. And I'll move quickly, and then I have a quick CLE announcement, so don't hop off quite yet. There are two additional cases that we did want to highlight. I will sort of give you the quick summary. In the Bowman Farms case, that was involved an agricultural company in Wisconsin. The allegations in that case involved subjecting female employees to a hostile work environment and then firing them in retaliation for opposition to sexual harassment. Prior to the lawsuit that was filed by the EEOC, a legal aid group brought a charge on behalf of a group of the female workers. The EEOC found cause to believe Bowman Farms had indeed engaged in discrimination, and then the parties engaged in what proved to be unsuccessful conciliation attempts. The EEOC regional attorneys and trial attorneys in the Chicago area, Minneapolis, and in Milwaukee brought a lawsuit on behalf of two of the women. And the allegations in that lawsuit were just directed at the actions of one particular supervisor. And some allegations that he had engaged in inappropriate behavior. This lawsuit was recently settled. There is a consent decree that is extensive. It is publicly available online, and I would encourage you to take a look at it. It puts some pretty detailed requirements on Bowman Farms that is to extend for several years, including a internal coordinator that is to come on site at Bowman Farms and make sure that they are in compliance with the consent decree. The U.S. District Court for the Eastern District of New York, there is currently a pending case there. This case involves an online tutoring company and allegations of age discrimination. So this is an example of that machine learning and AI technology and an allegation that's being used to systematically discriminate on the basis of a protected class. The allegation is that iTutor and their associated companies programmed their application software to automatically reject female applicants 55 and older and to reject male applicants age 60 or older which it's alleged to have resulted in more than 200 qualified applicants to be rejected based on age. That is still pending in the Eastern District of New York. There were some pre-litigation settlement discussions and later a conciliation process, which was ultimately unsuccessful. Those sort of highlight and are illustrative of what the EEOC considers to be their enforcement priorities. And I'd encourage you to take a look at those cases as they progress. All right, well, thank you for participating in today's CLE. In about 30 business days, you'll receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you are seeking credit in Kansas, New York, New Jersey, or Pennsylvania. Thank you so much for joining us.